Hi, my name's Ollie, and in this Politics Explained video, I'm going to go through everything you need to know about the US Supreme Court and public policy in Edexcel A-level politics. I'm going to start by looking at the parts of the specification this video covers, as well as the key essay questions you can get asked on the topic. I'm then going to look at judicial activism and public policy, introducing judicial activism, giving examples of judicial activism and its impact on public policy, and finally look at some arguments for and against judicial activism. I'm then going to finally look at judicial restraint, giving you an introduction to judicial restraint, Chief Justice Roberts and judicial restraint, and finally arguments for and against judicial restraint. So the PDF you can see on your screen is part of a updated textbook that you can purchase on the Politics Explained website in relation to Edexcel A-level politics and the US government and politics part of it, where you can also find loads of other resources to help you in your politics A-level, including essay plans, everything you need to know guides, which are effectively updated textbooks, and a place to sign up for tutoring if that's something you'd be interested in. But yeah, without further ado, let's get into it. So starting with the parts of the specification this lesson covers, this is in the kind of US Supreme Court and civil rights part of the specification of the Edexcel A-level politics specification, and it's 4.3, the Supreme Court and public policy, looking at the impact of the Supreme Court on public policy in the US with a wide range of examples, including examples post-2005, and the debate over the role of judicial activism and judicial restraint and criticisms of each. In terms of essay questions, this will be useful for. You can have a look at it in kind of the similarities and differences in rights protection in the US, differences in the roles or the powers of the US Supreme Courts for these 12 markers, and also some kind of more general ones, potentially in relation to comparing the Supreme Courts, but also maybe the impact of the Supreme Courts on policy and their kind of key roles. In terms of essay questions you could get asked, this would be really useful for a range of essay questions. It's not necessarily going to be an essay question in itself, but would be really useful when looking at whether the Supreme Court is political or judicial institution, whether there's an imperial judiciary, how effectively the Supreme Court protects civil and constitutional rights, its influence on public policy, and a range of other questions. So what we're going to start off with is judicial activism and public policy. But first, a quick note to say, and I'll put this in red kind of above, there are lots of cases in the notes below, and you don't necessarily need to memorise all of them for the exam. So don't feel overwhelmed that you need to know every single case. What's important, I guess, is knowing kind of, I suppose, at least 5 of them that you can use as examples for a range of points when answering essay questions. Yeah, starting off with judicial activism. So judicial activism refers to judicial rulings suspected of being based on personal or political considerations rather than existing law. It includes broad interpretations of the Constitution, overturning precedents, and expanding rights beyond the explicit wording of the Constitution. And activist judges are often seen as legislating from the bench in order to promote socially desirable outcomes or as being unduly influenced by their personal views. In terms of examples of judicial activism and its impact on public policy, the first key one is the Warren Court. So under Chief Justice Earl Warren, the court pursued an activist agenda by expanding civil rights, civil liberties, and federal power in the kind of post-World War II period. These decisions reshaped American society and jurisprudence, reflecting the court's proactive role in advancing social and legal change. Key examples of this include Brown v. Board of Education, where the Supreme Court overturned the separate but equal doctrine established in Plessy v. Ferguson. And this asserted that state-mandated racial segregation in public schools was inherently unequal and against the 14th Amendment's Equal Protection Clause, therefore struck it down and said that there couldn't be racial segregation in schools anymore. And this decision marked a significant departure from prior precedent and legislative intent, illustrating the court's active role in promoting civil rights and social change, particularly in the realm of racial desegregation in education. Also important was Miranda v. Arizona in 1966, and in this case the Supreme Court established the Miranda rights, requiring law enforcement to inform arrested individuals of their right to remain silent and have an attorney present during interrogations. This was seen as a proactive step in protecting the Fifth Amendment rights of suspects and reshaping police procedures. And it exemplifies the court's willingness to actively intervene in criminal justice practices to safeguard individual liberties. And finally, in the heart of Atlanta Motel versus the United States, the Supreme Court upheld the constitutionality of the Civil Rights Act of 1964, which prohibited racial discrimination in public accommodations. The court's decision marked a proactive stance in expanding federal authority by affirming the government's power to regulate private business, engage in interstate commerce, effectively combating racial segregation and discrimination on a national scale. So this effectively said that kind of public accommodations were defined under Congress's jurisdiction, so defined as interstate commerce, and this allowed Congress to protect civil rights in the United States, and the Supreme Court allowed this through its ruling. Other key examples of judicial activism are Roe versus Wade, which is often cited due to its significant impact on US abortion policy. In this case, led by Chief Justice Burger, it asserted that a woman's constitutional right to choose to have an abortion, there was a constitutional right for a woman to choose to have an abortion under the right to privacy derived from the 14th Amendment. And this decision effectively legalized abortion across the United States, overturning numerous state rules. Critics argue that the court went beyond interpreting existing law and legislated from the bench, making a far-reaching social and policy decision. This demonstrates a proactive judicial role in shaping public policy. And then the final thing we're going to have a look at is the Roberts Courts, which is, so judicial activism has traditionally been associated with liberal justices, as with these previous cases, who took a living constitutional approach and expanded civil rights, liberties, and federal power in the 20th century. In recent years, however, some critics have also argued that the Roberts Court has performed judicial activism to promote conservative values and political priorities, in particular in relation to Second Amendment rights, abortion, and campaign finance. And those on the right contest this, though, and argue that the Roberts Court has simply interpreted the Constitution from an originalist and textualist perspective, and kind of effectively gone back on some of these other liberal rulings and implemented the Constitution as it should be. A really key example of this in relation to gun rights is District of Columbia versus Heller, which is considered as an example of conservative judicial activism due to its reinterpretation of the Second Amendment. So the court ruled that the District of Columbia's ban on handguns and requirement for trigger locks violated an individual's right to bear arms for self-defense. And critics argue that this decision expanded gun rights beyond previous interpretations and historical context, effectively altering the understanding of the Second Amendment, which had previously been interpreted by many as a collective right to self-defense related to militia service. But now it had kind of been expanded to an individual right to self-defense, and it had really significant implications for gun rights across the US. In terms of campaign finance, Citizens United was a really key case, where the court ruled that restrictions on political spending by corporations and unions violated the First Amendment's free speech rights. And critics argued the court's decision expanded the role of corporations in politics and effectively equated corporate spending with individual free speech. And it overturned decades of campaign finance regulations and previous rulings, and was seen by many as an activist interpretation of the court, with far-reaching kind of consequences for campaign finance laws and the influence of money in politics. And a key example is in relation to abortion rights. Dobbs v. Jackson Women's Health Organization in 2022 is viewed as an example of conservative activism by overturning the nearly 50-year precedent set by Roe v. Wade. So the majority opinion, authored by Alito, argued that Roe v. Wade was wrongly decided because the Constitution doesn't explicitly mention abortion, and no such right is implicitly protected by any constitutional provision. The court concluded that the issue of abortion should return to the states, allowing each state to set its abortion laws without federal constitutional protection for the procedure. Critics argue that this reflects the current justice's personal political beliefs rather than a neutral application of the law, marking a proactive reshaping of legal and societal norms. But obviously, those who support the ruling argue that it's just a reflection of an originalist and textualist interpretation of the Constitution, and it was actually Roe v. Wade that was judicial activism and went too far. In terms of voting rights, Shelby County v. Holiday is a really key example, and this is when the Supreme Court considered the constitutionality of two key provisions of the Voting Rights Act, and effectively argued that these sections were outdated and an overreach of federal power. And so court invalidated the first section, section 4b, which effectively rendered section 5 inoperative, stating that the coverage formula was based on outdated data and unresponsive to current needs, and it therefore violated the principles of federalism and equal sovereignty of the states, even though it was attempted to kind of tackle discrimination through federal oversight. And the decision was kind of a setback for voting rights advocates, and it made it easier for Republican states to make it harder for minority groups to vote. A key other example is in relation to affirmative action in Students for Fair Admissions versus President and Fellows of Harvard College in 2023, and it brought into question the constitutionality of race-based affirmative action in higher education, a practice that had been subject to legal and social debate for decades. The lawsuit represented Asian American plaintiffs who alleged that Harvard University's admissions process was discriminatory against them. Harvard used race as one of many factors in a holistic admissions process and maintained that this was lawful and essential for fostering diversity and inclusion, consistent with previous Supreme Court rulings on affirmative action. In a 6-2 decision, the Supreme Court reversed the lower court's ruling and declared affirmative action in college admissions unconstitutional. This was rooted in the interpretation of the Equal Protection Clause in the 14th Amendment and Title VI of the Civil Rights Act. The court concluded that the use of race as a factor was not in line with the provisions, and this departed from previous rulings which had revolved around the 14th Amendment's Equal Protection Clause, and actually judged that rather than this invalidating affirmative action, it actually gave kind of protection or constitutional right to affirmative action in college admissions. This showed how kind of a reinterpretation of the law by conservative justices in different ways had a big impact on public policy in a conservative direction in the United States. But then finally, a different one to look at is under the Roberts Court, is actually how judicial activism can be used to update the Constitution in the modern world. And this is Riley v. California in 2014, where the Supreme Court unanimously held that the warrantless search and seizure of digital content of a cell phone during an arrest is unconstitutional and violates the Fourth Amendment. And effectively, advocates for warrantless searches argued that they were warrantless searches of cell phones argued that they were necessary for officer safety and to prevent the destruction of evidence, similar to searches of physical items. But opponents argued that cell phones, given their vast storage of personal information, merit greater privacy protections. And the court, emphasising the privacy concerns with modern digital data, ruled that the immense storage capacity and personal nature of data on cell phones required the police to obtain a warrant before a search. And this decision marked a critical advancement in the adaptation of privacy laws to modern technology. So it can be seen or argued that this shows how judicial activism can be seen as necessary to update the application of the Constitution in the modern day and to protect rights. So these were apart from that last one, these were a number of key Roberts Court decisions that kind of advanced conservative positions. On the other hand, it must be noted there have been a number of rulings under the Roberts Court that advance liberal values, despite the fact there's been a conservative majority. The key one is Obergefell v. Hodges in 2015, which ruled that the 14th Amendment requires all states to license and recognise same-sex marriages, effectively legalising it nationwide. Advocates for same-sex marriage argue that the bans violated the 14th Amendment's equal protection and due process clauses, infringing upon the fundamental right to marry and denying dignity to same-sex couples. Whereas opponents contended that marriage should be defined by states and maintained as what between one man and one woman, emphasising state rights and the democratic process. The court's 5-4 decision, emphasising equality and fundamental rights, marked a significant victory for LGBT rights and transformative moment in the legal recognition of same-sex couples in the United States. And it's seen by some, including Roberts, as an example of judicial activism on an issue that should have been decided by Congress, not by the Supreme Court, with Roberts actually voting against the judgment. In Bostock v. Clayton County in 2020, the Supreme Court ruled that Title VII of the Civil Rights Act, which prohibits employment discrimination because of sex, extends to discrimination based on an individual's sexual orientation or gender identity. Effectively, the court, in a 6-3 decision, held that firing individuals because of their homosexuality or transgender status discriminates them based on sex and violates Article 7 of the Civil Rights Act, therefore extending workplace protections to include LGBTQ individuals across the United States. And the majority opinion was written by conservative Justice Neil Gorsuch, which shows how it's not necessarily always a completely political decision. It can also be very much a judicial one, and shows that potentially Gorsuch had a respect for individual rights, even if some conservatives didn't agree with the ruling. So we're going to have a look at now, before we look at judicial restraint, which was a bit shorter, is arguments for and against judicial activism. So while judicial activism is a kind of contentious and multifaceted concept, supporters argue that in certain circumstances it's necessary for the judiciary to take an active role in shaping law and policy. The instances when it is necessary are of course contested based on where individuals sit on the political spectrum though. So on the one hand, it can be argued that it's necessary to adapt the Constitution to changing times. So advocates argue that judicial activism allows the law to keep pace with societal changes. So as societal norms, values and conditions evolve, strict adherence to the original meaning of laws and past precedents might not address current issues effectively, and activist judges can therefore interpret the Constitution and laws in a manner that considers contemporary context and challenges, and therefore ensures that the legal system remains relevant and responsive in the 20th century. This can be seen, for example, it can be argued that the expansive federal power was necessary, as was reinterpreting the 14th Amendment to promote racial equality, both of which were done in the Warren Court. It can be argued that judicial activism protects rights, is a key mechanism for doing so, especially for minorities and marginalised groups that may not have had the power to effect change through the legislative process. And in cases where the political process fails to safeguard these rights, the judiciary can step in to correct injustices and uphold constitutional values. And Liberals perhaps argues this was the case with Roe v. Wade, but Conservatives maybe argue this is the case the same about Dobbs vs. Jackson Women's Health Organisation. It also helps to fill legislative gaps, so sometimes legislators may fail to address pressing issues, or existing laws might become outdated and no longer serve their intended purpose. And judicial activism allows the courts to fill these gaps or clarify ambiguities in the law, and that's effectively what they're supposed to do, interpret and clarify the law, ensuring that justice can be served. And this can be seen in really important, complex and rapidly evolving areas of law, such as technology and environmental protection. So, for example, in the case of Facebook versus Dugan in 2021, the Supreme Court exhibited judicial activism by clarifying the definition of an automatic telephone dialing system under the Telephone Consumer Protection Act. This 2021 decision addressed the evolving technology of a kind of outdated act. By reinterpreting the law, the court updated its application to modern technology. This can be seen as really necessary to ensuring that there are no gaps in the legal system. And finally, it can be argued that it allows for the correction of poor decisions and injustices. So to correct previous mistakes or injustices entrenched in law by overturning previous precedent. So by revisiting and overturning these precedents, activist judges can rectify past wrongs and lead society towards a more just legal and social order. And that can be seen, for example, in Brown vs. Board of Education. On the other hand, there are a number of arguments against judicial activism, which typically emphasise concerns about the undermining of democracy and the separation of powers in the US Constitution. So on the one hand, it can be argued that it undermines democracy and separation of powers by giving unelected judges the power to make or change laws, which should be the role of elected legislatures. This can be seen as a form of judicial overreach that infringes on the sovereignty of the legislative and executive branches. And judicial activism is said to circumvent democratic processes, as it allows judges to impose their personal values or political beliefs on the public, rather than reflecting the will of the people or leaving it to Congress to decide. It can argue that it creates unpredictability and instability in the legal system. So when courts frequently overturn past precedents or interpret laws in new ways, it becomes difficult for individuals, businesses, and the government to know what the law is and how it might be applied in the future. And finally, it can be argued to encourage judicial bias and subjectivity. So opponents of judicial activism argue that it encourages judges to base their decisions on their personal beliefs and political biases, rather than the objective application of legal principles and establish precedents, which can undermine the impartiality and integrity of the judiciary, as decisions may be influenced by their individual views rather than the law itself, and that can kind of, in the long term, be seen as undermining the judiciary by moving it away from being kind of a neutral judicial institution towards being a political institution. Okay, so that was judicial activism. What we're going to have a look at now in the final part of the video is judicial restraint, which is a philosophy that encourages judges to limit their own power and suggests that judges should avoid overturning laws or actions by the legislature or the executive unless they're in clear conflict with the Constitution. And they should instead kind of closely follow the exact wording of the Constitution and its original intention rather than interpreting them in a flexible manner and letting their kind of personal political beliefs come into it. They typically interpret the Constitution in a literal or traditional sense and believe that the executive and legislature, not the courts, should make policies and make big changes to the Constitution. And this is crucially also known as judicial deference. Those who adhere to judicial restraint see their role as applying the laws as they are, respecting established decisions, so precedents, and generally deferring to the other branches of government in making significant changes to policies or societal norms. And this promotes stability in the legal system and keeps judges from imposing their personal views or making sweeping changes to laws and society. So, a key kind of figure who's been key in promoting judicial restraint and the philosophy of judicial restraint is Chief Justice Roberts. So he's often regarded as a key proponent of judicial restraint, emphasising the need for the court to respect precedent and the role of the other branches of government. In his tenure, he's shown a preference for narrow rather than broad rulings that limit the scope of judicial power and avoid drastic changes in law or policy. He often advocates for a minimalist approach, deciding cases on the narrowest possible grounds and leaving broader policy decisions to Congress and the President. And his rulings and writings reflect respect for established traditions and decisions of the court, and a belief in the limited role judges should play in shaping policy, favouring instead incremental change over sweeping judicial activism. So, the number of cases we're going to look at that can show this. So, in June, Medical Services versus Russo. And this relates to Whole Woman's Health versus Hellerstedt in 2016, when the Supreme Court struck down Texas's restrictive abortion laws, which were challenged as imposing an undue burden on women seeking an abortion. Justice Roberts was among the dissenters in this 5-3 decision, indicating his inclination towards upholding the state's law as a form of judicial restraint. His dissent reflected a respect for states' authority to regulate medical practices and a hesitation to invalidate legislation without clear constitutional conflict. However, in a later related case, June Medical Services vs. Russo, Roberts sided with the liberal justices to strike down a similar Louisiana law based on the precedents set in Whole Woman's Health. And this demonstrated a commitment to the principle of stare decisis and judicial restraint. His actions underscored a respect for the court's prior rulings and avoidance of abrupt legal shifts, even while his own views may not have changed. So even though he opposed the original ruling, he then upheld it in a future case, recognising that judicial precedent should be listened to, even if he disagreed with the original ruling. In Oberfeld vs. Hodges, Roberts dissented against the decision, emphasising judicial restraint and arguing that actually it was an example of judicial activism and overstepping the bounds of the judiciary. He argued that the Constitution doesn't address the issue of same-sex marriage and that it should be left to the democratic process, and expressed concern that the court was acting more as a legislative body than a judicial one, creating new rights rather than interpreting the law. And finally, the key case in relation to the Affordable Care Act is the National Federation of Independent Business versus Sebelius in 2012, where Roberts upheld the individual mandate of the Affordable Care Act as a constitutional exercise of Congress's taxation power. So although the mandate, which required Americans to have health insurance or pay a penalty, was contested as exceeding Congress's Commerce Clause powers, Roberts reframed the penalty as a tax, and this demonstrated judicial restraint and deference by avoiding a broad ruling that could destabilise existing law and respecting legislative authority, because if he'd kind of struck it down, it would have struck down the whole of the Affordable Care Act, which was a key healthcare bill passed by Congress. So he kind of grounded his decision in constitutional provisions, principles rather than personal political considerations, and it allowed the Affordable Care Act to stand, emphasising the court's role in interpreting, not making laws, and not using judicial activism to promote conservative policies. So there are a number of cases. The final thing we're going to have a look at is some arguments for and against judicial restraint. So the arguments for judicial restraint are the same as those against judicial activism, pointing out that unelected judges should respect democracy and the decisions of the executive and legislative branches, rather than seeking to influence policy themselves and introduce personal bias. Supporters also point out that judicial restraint promotes stability and predictability in the legal system and respects the clearly defined role of the Supreme Court in the Constitution to protect and uphold the Constitution rather than seeking to change the meaning of it. On the other hand, the arguments against judicial restraint are similar to those in favour of judicial activism. They point out that judicial restraint can lead to a failure to protect individual rights and minorities when executive and legislative branches fail to. And they also argue that those in favour of judicial restraint take a too literal and narrow interpretation of the Constitution, failing to adapt it to contemporary society. So yeah, that's everything in this video. This was the third of what's going to be 6 videos on the channel in relation to the US Supreme Court and civil rights, and the other 3 are going to be coming out very soon. Let me know in the comment section below if you have any questions or comments in relation to the video, and I'll get back to you, and I'll see you in the next video.